Morning everyone, and welcome to our webinar, the latest in our ongoing series of webinars covering all things Mental Capacity Act and deprivation of liberty. And what a day we've chosen for our webinar. We didn't anticipate when we selected the date that it would be such an important day. Perhaps if we did, we should have put a bet on. I hope that you can all still make sure that you vote today, and this is the second most important thing perhaps that you do today. So I'll just go through some housekeeping with everyone first of all. Your cameras and microphones are automatically switched off during this webinar, but you are able to interact with us and ask questions using the Q&A box. So we will monitor the Q&A box during the webinar and respond to some of those questions in writing while the presentations are ongoing. If your question isn't answered straight away, don't worry, it's because we've selected it to pick up later on in the Q&A section towards the end of today's webinar. If you have any technical problems, we have Diane on to help with that, but the standard solutions that you might need to try first are checking your device settings, classic try leaving and rejoining, and also potentially try disconnecting monitors so you just have the one screen up, because that can help. Today's session is being recorded and you will also have access to the slides which we'll share after the session, so don't worry about that. Your feedback's really important to us and we take that on board when planning future sessions. There will be a feedback form that crops up at the end of today's session, and we'd really value as many of you as possible completing that. Appreciate everyone's busy. It'll just take a few minutes, if that. So here is today's agenda. Our first presentation, I'm really pleased to welcome Jackie Hodgkinson on today's webinar. Jackie is a registered social worker who's got years of experience working in adult social care with a focus on safeguarding, and Jackie has now an independent social worker with her own consultancy, and she's very kindly agreed to come and talk to us about communicating with P in a capacity assessments. So I'm really looking forward to Jackie's session. Following Jackie, we will have our own Claire Christophilus and Emma Pollard, who will give you a case law update. And there's been some very interesting developments in the case law over recent months. And finally, Amy Clark's presentation will cover the Law Society guidance that's recently been published in respect of deprivation of liberty. And as I've mentioned, we will have a section particularly for question and answers towards the end of today. So we are planning on finishing at around 11:30 this morning. So I hope that is interesting and of use to everyone and what you were expecting. So without further ado, I will hand over to Jackie for her presentation. Thanks, Jackie. Oh, Jackie, you can't hear you.
Good morning, everybody. I hope you can hear me okay. Thank you for that introduction, Joanna. As Joanna said, I'm Jackie Hodgkinson, and I'm just going to talk about how we support P being the person that's at the centre of the decision. So firstly, I want to say that it's so important that we really do remember Principle 2 of the Mental Capacity Act 2005. And sometimes I think in practice this is sometimes forgotten, that actually Principle 2 is telling us that a person is not to be treated as unable to make a decision unless we have taken all practical steps to help him to do so. And I think it's not the responsibility of P to guess what we mean as professionals. We often use a lot of jargon that the people we work with would not understand. So I would say, in terms of my top tips, that support really means support. How can you evidence that you've supported and taken all the steps that you can to help that person make the decision for themselves? The whole point of our role in assessing capacity is to support the person to make the decision for themselves. It's as simple as that. It's not a test. It's not there to trick them. We need to actually record what we've done to help that person to make that decision for themselves. And that will be different things to different people. So what have you already tried? Have you recognised that maybe P has difficulty in speaking clearly? Maybe P has difficulty in producing words and difficulty in understanding what others are saying. The person may have difficulties with reading and writing, may have difficulty and only understand symbols. And it might be that we need to look at different ways of communicating rather than just using maybe the written format or oral communication. We also need to think about, when we're looking at assessing whether P can make the decision for themselves, can that decision wait? Now, there are some decisions that obviously are life-threatening, and in those situations, obviously, decisions will need to be made in somebody's best interest if we've established that P is unable to make that decision for themselves. But sometimes we need to think about, can this decision wait? Is it that P doesn't fully understand the information? Then actually, in providing information in bite-sized chunks or providing information with additional education, the person may have and demonstrate capacity at a later date. So, for example, if you're assessing capacity around a life-changing decision about changing residency, it would go without saying that you wouldn't say to somebody, the options are go home or go into a nursing home. Somebody may have never seen a nursing home. They might not know what sheltered accommodation looks like. So part of that education and part of that communicating with P would also be about providing the information to enable the person to make an informed decision. That could involve going on trips to the different establishments so that the person can consider option A or option B. Although these may seem quite obvious and practical steps, there is so many times as a social worker where I've seen that this hasn't happened and decisions have been made on behalf of P without truly giving the person the right information to enable them to make that decision for themselves or engage in that decision. So always, context is everything. We say this a lot in social care and healthcare. So have you considered the time of day when communicating so that we know when working with a person with dementia, there will be certain times of day when they are more alert, more orientated in time and place. It isn't exactly the same for everybody, so it's worth checking out with their carers or with their loved ones about, so what time of day works better? How is P in the morning, or how is P in the afternoon? Equally, if you've worked in mental health services, a lot of people who have enduring depression really struggle with motivational energy, and that is often worse in the morning, and actually they have a better experience of being able to understand information later on in the day. But again, there is no magic formula here. It's about understanding P's cycle and understanding who's important to P. So who do they want to be present? If you're working with an adult with a learning disability, if they got a trusted carer, or is a parent someone who can communicate well with that person? What about the environment? If you're working with somebody with autism, you'd want to ensure that the environments can. to actually providing information. We don't want that person to feel agitated or overstimulated in a noisy place. And have we given them, and can we demonstrate that we've given all of the information that's relevant to support their decision? Because at the end of the day, P is the centre of the decision making. I do think sometimes I've seen in my experience assumptions made that P lacks capacity because we've not taken the time to provide additional. And reasonable adjustments are so important so that P is protected. And it protects you as a practitioner and as a professional under the Equality Act. So what adjustments have we made to ensure that P is fully involved in the decision, and that actually we've provided that information in the right way to enable P to make that decision? So I'm just going to give you a case example from my experience. P's family had decided that P shouldn't have contact with a friend whom P had known for a number of years. P was very good friends with this person, spent quite a lot of social time with this person. The family decided, for reasons that I can't discuss, that P shouldn't see this person anymore. And this was done without any legal authority. Both the family and the local authority made huge assumptions about P lacking capacity to make this decision. And they did this based on the basis that P was unable to communicate verbally. So it was decided that it was in his best interest to not have contact with a person because P was not able to verbally demonstrate his preferences. There was no consideration in the best interest decision making about the importance of long-term friendships and the impact on P. And sometimes when making decisions and supporting people to make decisions, we can be rather risk averse. And I think when providing information, we need to be aware of our values as well. And we need to be aware of the values that we place on certain information in terms of the weighing up of information. So it's not always easy. We might have those unconscious biases that sort of place more emphasis on one set of information rather than another. And I think it's important that we don't overburden a person with too much information, but we give them enough information to make that decision for themselves. So just going back to P and the fact that his contact was stopped with a long-term friend. An independent social worker was appointed because this was a case that went to court of protection for a decision to be made on a range of decisions involving social contact, relationships, finance, care and support. The independent social worker spent a lot of time getting to know P, and that's not something that if you work in health and social care, you're actually blessed with is time. So the social worker used different games with pictures on, similar to the Guess Who type of game, to promote a discussion about who was important in P's life. So a range of photographs were used with happy faces, sad faces, neutral faces, which is something P was able to use and understand. And P was really strongly able to communicate their beliefs and their values. And he could point to the individual pictures to show who he liked, who he disliked, using happy and sad faces. And although the social worker assessed him as lacking capacity to make the specific decision in relation to social contact, it was very much evident through her assessment that P's wishes and feelings were going to be a major part. So the magnitude of his beliefs or his wishes and feelings were very much central to that best interest decision. Now, prior to this independent social worker getting involved, it had been didn't have a view. He didn't like this person. There was no loss to him in not having contact. Where the strength of his feelings very much came across through the different approach that the social worker took. So, you know, all I really would say that using a SALT assessment, which is a speech and is really important, whether that be using game, using pictures, words or symbols. Think a little bit outside the box. Think about, how can I get these points across to somebody in a way that they understand? And our speech and language therapists are excellent at communication. They're not just there to support you assessing around swallowing. And I know from a previous piece of research that in only about 30% of mental capacity assessments were the expertise of SALT team accessed. So they've got a wealth of information. So if you've got a situation where you're not sure that you've provided the right information to P, always request a SALT assessment, even if that means delaying an assessment, so that we can be really sure that the wishes and feelings of P are at the centre of what we're looking to achieve. So how do we get, I like to break things down into really simple steps, because that's how my brain works. So firstly, I would say, be clear. So sometimes when we're faced with really complex situations, we get sort of like sucked into the mud, and we're very much unclear about what the decision is, and we get really sucked into other people's risks and values about what P should or shouldn't be doing and what's risky, and the safeguarding concerns going on. So it's very much about making sure that we're very clear about what the decision is. Is the decision about care and support? Is the decision about housing? Is the decision about finances? Is it about social contact? Is it about residency? What is it about medication? Whatever that decision may be. So we've got to, as the lawyers say, identify the matter at hand. And we should always, in giving the information to P, support the person to understand what are the reasonable foreseeable consequences of deciding one way or another, or what will happen if we don't make any decision at all. And so an example might be when P is leaving hospital, P is going to live back at home, and everybody's very risk averse and saying, well, what happens if P has a fall? What will P do if they're lying on the floor? And we've got to consider, would we be risk assessing everybody? Would we be using the same risk appraisal for everybody? Or are we sometimes skewing that if we believe that someone lacks capacity and we're worried about their safety when they go home? So it's about not overly burdening someone, but looking at the reasonableness of the consequences, so that we don't sort of go from 0 to 10 in terms of our risk assessment. Secondly, providing all that relevant information. So recording what communication have we used? Have we revisited the information? Have we provided concrete examples? As I said earlier, have we actually taken the person to look at the accommodation? Have we actually gone through money management with them? Have we got, you know, if we use some cash in front of us to demonstrate whether they can understand the transaction of money, rather than perhaps just talking about it in the abstract or giving somebody a leaflet. The third bit is always considering about whether the person can execute that decision. And I know that's been talked about on previous webinars. So it's about, can that person walk the walk as well as talk the talk? So have they got the ability to execute the decision, as well as in the abstract talk about what they're planning to do? So mental capacity is not only about that ability to understand the consequences, which is what you call decisional capacity. It's about kind of understanding what the consequences may be in reality and in practice. So for example, if I spend all my wages today, I'll not be able to pay my rent this month. So that's understanding the consequences of my decision. But it's also about that ability to carry out the decision. So that's sort of the executive. So many times, particularly sort of somebody like an occupational therapist may go out and do an assessment, and they'll say, are you able to make a cup of tea? Yes, I make 3 meals a day, when actually the family are telling you that if nobody cooked for them, they wouldn't actually make a meal, or they wouldn't have a drink and they become dehydrated. A simple way to tell me then, show me how you do that task, and to do that obviously in a very non-confrontational way, is to support that person in assessing really whether they fully understand what the task is. So again, just going back to decisions and communicating decisions, I think the most important thing is you need to be clear about what the decisions are. And I've put here a suitcase of decisions. That's just because I was writing this on the morning I was going on my holidays, so suitcases were on my mind at the time. Decisions are usually specific, and they're not always related to other decisions. However, there has been some case law that has demonstrated that sometimes decisions are interrelated and you can't separate one from another. So residency and care support may be interconnected, but sometimes other decisions will be separate. So that's as well. So, for example, this is a situation of D, who's a person with autistic spectrum disorder. He's been criminally and financially exploited by local youths. He's currently living in a supported accommodation and is in arrears and is at risk of being evicted. Social worker is assessing his capacity regarding managing his finances. He appears to verbally have a really good grasp of what bills he must pay and how much benefits he receives. So in the abstract, he's very good at communicating in a literal sense how much money he has coming in and how much is going out. Because he's got this very abstract grasp of his finances, he's assessed at having the capacity to make an unwise decision, which is Principle 3 of the Mental Capacity Act. Although he gives significant amounts to the local youths, because he can certainly talk the talk. And therefore, the fact that he's being criminally exploited is deemed to be his choice to make unwise decisions. But D has no awareness of the consequence of his spending, and he struggles to manage his impulses. He's daily phoning his family up, distressed that he's got no money for foods or to pay his bills. There are a number of decisions here to be made, and they are specific decisions that are not just around his finances. There is one decision around financial management. There's one around his ability to manage risk and understand risk and personal safety, about the residencies he's in and the risk that poses to him and to other people because of the associations that he has, and his need for care and support. A lot of this was overlooked because of how we verbalised his choices that he made. And again, it was a particularly complex situation that was difficult to unpick, because on a verbal level, he appeared very superficially to understand the decisions, but his executive decision-making didn't really match with what he was saying. So in summary, Principle 2 is such an important principle. It's there to promote autonomy. which includes the autonomy of decision making. So we can't really move to principle 3 if we've not really explored fully principle 2. We need to give people the right information to make the right decisions for themselves before we can say they've got a right to make an unwise decision. The mental capacity is an empowering law which safeguards the rights of individuals, and we should always embrace that, and we should safeguard that right. But we do need to always be mindful that we need to take stock of our role in supporting that person to make an informed decision. Remembering that the SALT team are a fabulous report who've got an extensive knowledge of communication styles, and I can't emphasise that enough if you haven't worked with speech and language therapists. And it's our duty in the roles that we have to make sure that we make those adjustments, those reasonable adjustments when communicating with P. So I'd like to thank you for listening to my presentation, and that's all from me today.
Oh, thank you so much, Jackie. That was really helpful. Some great practical guidance, and really brought to life with those examples that you were able to share. So thank you so much. We very much appreciate you joining us today. We're going to move on now to our next presentation, which is Claire Christophilus and Emma Pollard bringing you a case law update. So over to you, Claire.
Thanks, Joanna, and thanks, Jackie, for your presentation. So Emma and I are going to do a bit of a case law update today, and we're going to focus that case law update on looking at the recent challenges to the Cheshire West acid test. So we're going to go through a couple of recent decisions, and in fact a decision that came out just a couple of days ago as well. So first, before we get onto those cases, it's probably helpful just to remind ourselves of what happened in Cheshire West and the Cheshire West acid test. This case essentially created what we all rely on now as the test for determining whether a person is deprived of their liberty. And there's essentially 3 elements to the test: that they are under continuous supervision and control, that they are not free to leave, and that they lack capacity to consent to those arrangements. And it's probably worth noting as well that in Cheshire West, we were looking at 3 particular individuals who had the physical capability to get up and to leave their home, but lacked capacity to consent to those arrangements. And it was about putting in place a lawful regime to prevent them from leaving the home. It was held in Cheshire West, however, that it was irrelevant whether a person was compliant or not objecting to the restrictions. And I think it's that point which is key to what happened next in terms of deprivation of liberty being expanded and creating a huge number of cases which were considered to amount to a deprivation of liberty where perhaps they hadn't before, because people weren't objecting to the restrictions in place. Now, one of the cases that I'm going to come on and look at, one of the more recent decisions, is about a child. So I just thought it might be helpful to remind ourselves also of how deprivation of liberty relates to children. And some of the key cases are on the screen for you there. So the Re-D case is essentially a helpful case that gives a bit of a blueprint for what age of children might likely be deprived of their liberty. And generally speaking, although each case, of course, is case specific, a DOL of a child between the age of 10 to 16 lacking Gaelic competence generally can be authorised by a person with parental responsibility. However, in that case, the court held that the local authority as a corporate parent cannot consent to a deprivation of liberty on behalf of a child in their care. However, and there is a big however, which has only come up in the last couple of days, there was a decision from Mrs. Justice Levin that was published this week. It's called Re-J. and a bit of a surprising decision, I think it's fair to say, for most people, where the court held that, in fact, a local authority can, in its exercise of corporate parental responsibility, consent to the confinement of a child under 16 subject to a care order, so as to take the circumstances out of the scope of Article 5 and not require court authorisation of a deprivation of liberty. Now, I won't say too much about that case at the moment. It's safe to say that it's difficult to reconcile that decision with previous case law, including in the appeal courts, which would be a higher authority, which have consistently held that where a child is subject to a care order, whether that's an interim care order or a final care order, neither the local authority nor a parent can exercise their parental responsibility to provide valid consent for a deprivation of liberty. And the basis for that approach previously has been that by taking a child into its care, the local authority is acting as an organ of the state to confine that child, and therefore to permit that same local authority to consent to that deprivation of liberty would not be in compliance with Article 5. So we're not going to say too much more about that case. As I said, it's only come out in the last few days, and we'll have to wait to see whether it will be subject to an appeal or not. I think it would be very helpful if it was, because otherwise there might be a little bit of confusion moving forward as to whether local authorities can or cannot consent to the DOL of children in their care. The case of Re 8F is also on there as well. That essentially gives you a bit of a rule of thumb for younger children and what would constitute confinement. And essentially from age 12 and above, the courts have held that it's more likely that the threshold for confinement will be met if a child is confined and no person with true parental responsibility, bearing in mind what I've just said about that being a little bit ambiguous now, if they cannot consent on the child's behalf, then an application to the court to invoke the inherent jurisdiction should be made. Okay, so moving on to the recent cases that we are covering today. So I'm going to cover the case of Re SM, which was another case decided by Mrs. Justice Leven. So you can see that, perhaps Mrs. Justice Leven in particular is pushing at the door of Cheshire West and challenging some aspects of that decision and questioning whether, not necessarily whether that decision was correct, but whether it has been applied correctly moving forward. And this case raises a very important issue about the requirement for a deprivation of liberty in the case of a very severely disabled child. So this was an application brought by the local authority. SM was a 12-year-old girl with profound disabilities. She was non-mobile, non-verbal. In practical terms, she was physically unable to get up from her bed, leave the house. She was unable to communicate in any form. SM was made subject to a final care order in 2022 and lived with foster carers. And so, obviously Leven's more recent decision wasn't out at the time. So the previous understanding was that local authorities could not consent to the deprivation of liberty for SM, and that's why an application was brought to the court. The local authority sought authorisation for various restrictions, some of which are arguably not DOL, and we'll come on to look at that. But the restrictions that were in place included one-to-one 24-hour care, support with all aspects of her personal care and feeding, bed rails to prevent falls, locked doors, although that was more to just secure the building rather than to prevent her from leaving because she wasn't able to leave, and then 2-to-1 support when she was out in the community. The issue was that the guardian representing SM opposed the making of a DOL order on the basis that it wasn't necessary on the facts of SM's case. And Mrs. Justice Leven, as I said, considered that many of the restrictions were part of SM's care provision and not actually actions that were intended to deprive SM of her liberty. So, for example, it was said that SM was not free to leave her foster care placement because of her physical and mental disabilities. It wasn't actually due to any restraint being placed on her or enforced upon her by the local authority. And so Leven said that essentially there wasn't a deprivation of liberty arising by definition of the test in Cheshire West. And it differed from Cheshire West because that case focused on preventing individuals from leaving their home if they tried to do so. Whereas in this case, that was not something that SM was able to do, and the restrictions were part of her care package. And the judge commented that there are many aspects of a person's care which might intrude on an individual's privacy and their autonomy, and that interference may be justified. But they are not necessarily interferences with the right to liberty enshrined in Article 5. And that's what the focus needs to be on, is what is the intention behind this. And the quote from the judge essentially is that the local authority, in bringing this application, took the principles of Cheshire West to a logical but extreme conclusion that defied common sense and was not required by the Cheshire West Supreme Court decision. And she said that Cheshire West does not deal with the situation of a child such as SM, who is incapable of leaving because of a combination of her physical and mental disabilities, and not by the restraints placed upon her. So fundamentally, what the judge found in this case is that for there to be an unlawful deprivation of liberty and therefore a breach of Article 5, it has to be attributable to the state, whether by way of physical restrictions or by preventing someone from leaving by verbal persuasion or psychologically making them believe they're unable to leave. In this case, as I said, SM couldn't leave because of her physical disabilities. It wasn't because of any action or inaction of the state. And the supervision and control, again, was not to prevent her from leaving, but to meet her care needs. There was a lot of discussion in this case, as there was in Cheshire West, about sort of comparing people of the same age or comparing a child of the same age. And the judge held that that would be difficult to do in the case of any child, because there are different levels of maturity among children of the same age. But more fundamentally, she said that in SM's case, that would be a wholly unreal exercise, because SM functions cognitively in a way comparable to a baby. And so do you compare her with a baby, or do you compare her with a 12-year-old child? There was also some suggestion that from the local authority that if the court were to find that SM was not being deprived of her liberty, that would in fact be discriminating against her as a disabled person. And again, this was something that was raised in Cheshire West. It wasn't an argument that was adopted by the majority of the judges, but it was a comment that one of the judges made. It isn't part of the final acid test, but it has been transferred across to subsequent case law. And in SM's case, the judge's view was that in order to discriminate against SM, it would be necessary for there to be different treatment between people in a relatively similar situation. And so comparing SM to an able-bodied 12-year-old was not appropriate because there was a material difference between them. And on that basis, she found that she was not discriminating against SM. Emma's going to come on to look at another case, and we'll kind of wrap up where this case leaves us. Again, I suppose I would just say this decision is there. It's helpful in a sense, but it has to be approached with a degree of caution, I think. Emma?
Thanks very much, Claire. Yes, so I'm going to be talking about another case called HC, which similarly raises kind of questions and challenges around Cheshire West, but in a slightly nuanced way. So this one was one that was before Tor Butler Cole, who I suspect most of you will have come across. She's a KC and a barrister with significant experience in deprivation of liberty cases, and was sitting as a Tier 3 judge in this case. So HC is a 27-year-old, and I always love when a judgment starts by humanising the individual at the heart of it a little bit more. So Butler Cole explained that she's got a degree in photography and videography and enjoys yoga and rock climbing. I just think there's something so nice about that for those of us who are doing these kind of cases day in, day out, just to be reminded that there is a person at the centre of this. I think it's really, really helpful. So unfortunately, HC had some mental health difficulties as a teenager and was diagnosed with anorexia shortly before going to university. She had a history of hospital admissions, including some under the Mental Health Act, so detentions. And most recently, she was discharged from hospital, I think it was November last year, to a placement that we'll call K House. And then unfortunately, they gave notice a few months later, so I think it was around April of this year. So that led to the local authority and the ICB, which have the Section 117 responsibility. So that responsibility under the Mental Health Act to provide aftercare services. They applied to the court for an urgent determination as to whether it was in HC's best interest to be moved to this new placement, which we're calling D House, immediately and using restraint if necessary. Actually, by the end of the hearing, there were two options on the table. So we had this kind of forced move to a new placement if she wasn't willing to go there. And then there was an alternative option of a temporary return home to live with her father, RC, if she wasn't willing to move to the new placement when the notice for it expired. There were some concerns around her living with her father. I think it's quite a complex history of dependence on him, and some concerns around non-engagement with eating disorder services. So in terms of the decisions that Butler Cole made, starting with capacity and best interests, she felt that Section 48 of the Mental Capacity Act was satisfied. So there was reason to believe that HC lacked capacity to decide where to live and receive care. But Butler Cole also accepted the OS's submissions that there were omissions in the evidence around capacity, and it was entirely possible that in due course HC would be found to have capacity for the purposes of Section 15 of the Mental Capacity Act. So that's the kind of higher bar of capacity rather than the more interim decisions that you get with Section 48. And I think that really helpfully ties in with exactly what Jackie was talking about in terms of the sort of practical support we can provide with capacity assessments to make sure that we do have that really thorough evidence there and there are less question marks around capacity. And then in terms of placement and best interests, Butler Cole had concerns about HC living with her father, kind of in line with what I mentioned before, but actually even greater concerns about a forced move. So that was particularly because a move would be against the will of her father, which was likely to cause HC herself significant distress. Butler Cole also felt that HC was unlikely to settle into a placement if she felt she'd been forced to go there. And finally, and really importantly, the judge found that physical restraint at this particular stage would not be necessary or proportionate and would instead likely be a further source of trauma for HC. So what Butler Cole did was she consented on HC's behalf to a move to this new placement at D House, but only if she was willing to go there herself. And if she wasn't willing to go there, then the judge consented on HC's behalf to a move home with her father, RC, on an interim basis with a care package in place, and noting that there'd need to be either some agreement from RC or court orders that would ensure that professionals could have access to her and would be able to speak to her without RC being there. There were also orders made seeking kind of further evidence and for the case to return to court. Then we get to the DOL point, which is where things get really interesting. So this new placement, D House, was a locked facility. So there was a question raised about whether or not an urgent and then a standard authorisation should be put in place at D House. That was something that the official solicitor submitted should happen. Butler Cole didn't consider that to be appropriate. So firstly, because she felt that urgent authorisations have not been designed for a planned move such as this one. And then secondly, because the test for capacity that sits within the standard authorisation, so when the local authorities completing all their DOLS forms, that capacity test is essentially equivalent to a Section 15 declaration on capacity, which wasn't something the judge had made. She just made the declaration that there was reason to believe a lack of capacity under Section 48, so that kind of lower bar than a Section 15 declaration. And because of the complexities around capacity in this particular case, so those omissions of evidence that we referred to, and the risk that that DOL assessor may then find that she has capacity and then wouldn't be able to put a standard authorisation in place, the matter would then need to return to court for an urgent hearing. So Butler Cole wasn't persuaded by that suggestion from the official solicitor. The official solicitor went away and reflected on this and then submitted that it should actually be the court who authorises the DOL. And Butler Cole felt that there was an inconsistency between, on the one hand, determining it's in HC's best interest to move only if she's agreeable to do so, but then on the other hand, once she gets there, preventing her from leaving if she changes her mind and decides she wants to go home. Which I think raises a really important sort of question around Cheshire West and DOLS, because there would still be, objectively speaking, a deprivation of liberty when we look at the acid test in Cheshire West. And there was reason to believe that she lacked capacity. So the court did have to provide substitute consent for the deprivation of liberty while she was residing there willingly. So Butler Cole essentially authorised that deprivation of liberty, but with the important caveat that the authorisation would end if HC changed her mind and wanted to return home. And if that were to happen, then the case would have to return to court for further directions immediately. So you do still end up in this really unideal situation of having to return to court on an urgent basis, similarly to what we are trying to avoid with the capacity issue that might come up with the standard authorisation. But I suppose, at least in this case, the focus for the court would then be on the best interest elements of things and the placement options rather than the capacity dispute itself. But it does raise a really important question, or a couple of really important questions around, firstly, if HC is there willingly and the DOL is only being authorised while she's there willingly, then why do we need the court to be giving consent on her behalf? Is it not enough that she is willing to be there? And I appreciate her willingness may not be a capacitous decision, but, wishes and feelings should be at the heart of all of these cases. And if she was willing to be there, is that not enough, essentially? And then I suppose the follow-on from that is, if she is agreeing to be there and she is willing to be at the placement, then why should it be seen as a deprivation of liberty? So where does that leave us? I think the sort of very professional answer to that is in a bit of a mess. I suppose it's important to start by saying that Cheshire West was really important in shining a spotlight on the restrictions that are in place in a whole host of settings, and often against some of the most vulnerable individuals in our society. And there is a really important message behind it around the right to liberty, and how that should mean the same for everyone, regardless of potential disabilities. But I think it's fair to say that the definition of a deprivation of liberty from Cheshire West was definitely much broader than had been commonly understood at the time. And there has been a bit of a snowball effect since, of kind of really widening the scope for DOLS quite significantly. We've seen the consequences of that playing out over the last kind of 10 years. Huge numbers of people whose arrangements constitute deprivation of liberty. We've got lengthy backlogs to authorise even the most straightforward kind of community deprivation of liberty cases. That's both within the ICBs and the local authorities themselves, with the kind of significant resource implications of having to complete all of these, the COP-11s, following the so-called streamlined procedure, which is really anything but. And then also we're seeing huge backlogs in the court, which has really escalated since COVID. And I know they've said that things are improving on that front, but I'm yet to see that myself. And really, we're still seeing up to 12 months or so delay for the court to consider these kind of applications and actually authorise the deprivations of liberty. It's not surprising when you look at the figures, and I think the year before Cheshire West, there were maybe around 14,000 applications to court for deprivations of liberty, and the year after it had gone up by something up to like 140,000, and it's been going up steadily every year since, I think around 10% or so, don't quote me on that. So it's not difficult to see how that will have such significant resource implications and has essentially made this entire process really quite challenging for people to get through and to make sure those deprivations of liberty are being authorised. We're certainly seeing more of these kind of cases, particularly from Leven, where judges are challenging elements of previous decisions, including Cheshire West. But what we really need is for one of these cases, or probably a couple of them, to be appealed and to get all the way up to, the Supreme Court, so that the Supreme Court can reconsider some of these issues and hopefully provide us with some clarity as to the way forward. Because at the moment, all these decisions that are coming out are kind of first instance. So we really need to see some appeals, but it's whether anyone's got the appetite to do that. So in the meantime, I think we have to approach some of these first instance decisions with caution. So, particularly like the Re-J case that Claire mentioned. And essentially, we are still bound by the acid test in Cheshire West. I think the Law Society guidance is probably a really helpful kind of tool in the interim to help us practically in identifying deprivations of liberty, and it kind of brings things as up to date as possible. So it's very handy that I'm now passing over to Amy, who's going to talk you through that exact guidance. Thanks, Amy.
Thank you, Emma. Yeah, you beat me to it. We're very much on a DOL theme here, and I'm going to close out the session today by spending sort of 20 minutes talking through the recently updated guidance from the Law Society on exactly that question: how to identify a deprivation of liberty. And I'm sure, given what we've just all discussed, it's a welcome move for you all, practitioners, providers, commissioners and lawyers amongst us, especially with the announcement last year of the indefinite delay to the implementation of the LPS and the associated code of practice that was going to come with that. So let's dig into it a little bit. The Law Society guidance was originally published in 2015, just to put a bit of this into context, and it was commissioned from the Law Society by the then Department of Health to assist professionals mostly directly concerned with either commissioning or implementing or having oversight of arrangements for care and treatment of people who lack capacity to consent to those arrangements. And its purpose at the time was to provide practical assistance in identifying whether that person was or may be deprived of their liberty, and hence to ensure that steps were then taken to secure their rights under Article 5 of the European Convention of Human Rights. So the guidance was published in 2015.
as identifying a deprivation of liberty, a practical guide. And since the publication of that guidance, which is 9 years, there have been, we've touched on in this webinar and in many others, there have been important developments in the law relating to deprivation of liberty, including in particular, for example, clarification of the position of those under 18, which Claire has touched on in her case law update, and also those in receipt of life-sustaining medical treatment. So the updated guidance, which was published in March of this year, makes it clear that for several years it had been anticipated that these developments would be reflected in an updated version of the statutory code of practice, in other words, guidance that had been approved by Parliament. However, without that updated DOLS code of practice, bearing in mind Chapter 2 of that code deals with guidance on identifying a DOL, but it predates Cheshire West. So without that updated DOLS code of practice on the horizon, I think this updated Law Society guidance might feel like a very welcome next best thing, if you like. So as I've said on the slide there, the guidance is based upon the law as it stood in January of this year. But as we've touched on, there's been case law since then even on this exact issue. So it's always important to keep abreast of new cases and developments, and the High Court and the Court of Protection, as I say, are very busy courts with judgments coming out all the time on these kinds of issues. So that's a bit of background on the guidance itself. A few practical questions before we dig into it in a little more detail. So who is it for? Who is it intended for? The authors of the code understand that this will be close to the hand of lots of lawyers, such as ourselves, but the primary audience, it is said, are frontline sort of social and healthcare professionals who need to be able to weigh up whether an individual they are concerned with may be deprived of their liberty and then take appropriate action. So it's that question of might they be deprived, and that is the threshold for considering it further or undertaking proper assessments. You don't have to be certain that it is, it's might they be. And this guidance is really framed in that way. So that's who it's for. How should the guidance be used? Well, I'll get on to how it's not how you would navigate it, but in terms of how it's approached the guidance, it first of all, for a particular setting, which I'll get to, it identifies factors that might point towards there being a DOL. So the guidance calls these liberty restricting measures, and they are practices that social workers or healthcare staff may or may not normally consider to be restrictive. So it starts off with that identifying those relevant restricting measures first. And then what it does in relation to those is offer a sort of practical case scenario or scenarios, and you will see in the talk that I'm doing that what the guidance does is it breaks a particular scenario down into very likely to be a DOL, might be a DOL, need to ask some further questions, dig into that a little bit more, and unlikely to be a DOL. And then what it does also is pose questions around that. Professionals can ask themselves to identify which side of the line a specific situation may fall. And then just finally, on a practical note, it's and I have done this, it's easy to navigate because it is a lengthy document, but online it's separated into separately downloadable chapters. There are hyperlinks to transcripts of case law where relevant. So you can go to the particular area or setting that is relevant to you, or you can download the whole thing and navigate it that way. So a couple of the highlights before we dig into some of the detail on it. Chapter 2 outlines the central principles of Article 5 of the European Court of Human Rights. It summarises key elements of the Supreme Court's 3 decisions concerning a deprivation of liberty, so Cheshire West, Re D, which Claire has already mentioned, and the Ferreira case, which was about the carve out for life-sustaining medical treatment. So Chapter 2 really deals with the rehearsal of the law, if you like, and is a good refresher for anybody, including ourselves. There is then a specific chapter dealing with under 18s, which, as again we've sort of talked about, is a notoriously tricky area, which is also fast developing in the courts. The numbers of child and young person sort of DOLS applications has increased quite rapidly. And so there's a whole chapter dedicated to that age group. And thereafter, the guidance is separated into different settings. So hospital, psychiatric settings, care home and different types of care home, supported living, own home, and then finally hospice or palliative care, whether that be in a hospice environment or at home. So for each setting, what the guidance does is it provides that list of potentially liberty restricting factors which may indicate that a DOL is occurring. And then, as I say, the guidance explores various scenarios. And I've taken the opportunity to cover some of those for each setting. Conscious of time, but I will flag the sort of more relevant ones to you. So if we start with the hospital environment, chapter 5 covers hospital, and it covers various examples of DOLS within that environment, but also during conveyance to and from hospital, which I know again can be quite a sort of tricky area to navigate, but it covers A&E, ICU and acute wards as well. So the majority of patients who lack capacity to make decisions about their care, treatment, admission and discharge can be treated in their best interests under Section 5 of the Mental Capacity Act. It might be that a separate application to the Court of Protection regarding care and treatment is required. That's not what this guidance is about. But what it talks about is that challenge in identifying when reasonably necessary restrictions do amount to a DOL as a result of the level, duration and intensity of them. There is also mention in various parts of the guidance of the Ferreira exception in relation to life-sustaining treatment in intensive care. And there is some talk in that around the fact that there is an exception there that applies in intensive care. There have been some cases that extend that beyond intensive care environment, but the guidance puts a note of caution in there that the longer a patient is in hospital, the further down that acuity slope they progress, so the better they are getting, the more the treatment becoming sort of less life-sustaining, and in that way, the harder it may be to characterise their treatment as within that Ferreira exception. We could spend quite a long time just dealing with Ferreira and that carve-out, but the hospital environment obviously is where that applies, and that is why the guidance spends a little bit of time on that. So you will see on the slide, and this will be, I'm hoping you can read the content of the slides here. I've got another one up here just on my big screen so I can read through it. But as I mentioned, what the guidance does for different settings and different places within each setting, provides 3 case scenarios, and one where it says this is likely to be a DOL, one where it says this may be a DOL, and one where it's unlikely to be a DOL. In this particular instance, I've set out the key facts, for example, on a hospital conveyance, so not within the hospital environment, but at a conveyance to hospital. For example, Jane is 35, she lives alone and she has a moderate learning disability and can be violent at times. She is 7 months pregnant, but is currently denying that she is pregnant. Despite all attempts, Jane is refusing to engage and will not attend any appointments. The local authority and relevant acute trust make arrangements for admission to hospital for Jane to undergo an antenatal assessment, and a plan is put together for that. That involves access to the property with the police input if needed, physical restraint and sedation if necessary, and transfer in an ambulance by professionals employed by the trust. And that journey is approximately an hour plus. So that is likely to be a DOL, and the guidance will elaborates on that to say the key factors pointing to a DOL is the potential involvement of the police here, and that Jane may be taken to hospital against her will, the potential use of sedation and physical restraint, and the journey time itself being over an hour. Now, you would also expect there to be, in and around this, some authorisation for the treatment for Jane as well, not just the DOL for the conveyance, but because this guidance is dealing with the DOL question, it's focusing on that. And then on the same sort of theme, we deal with Ahmed in the middle there, where it may be a DOL, so he has a sustained head injury, admitted to local trauma unit, but requires transfer to a regional centre 5 hours away. He's sedated, intubated and ventilated. He'll require continuous care and monitoring during the journey. Now, this is where it might provoke some discussion. Is this really a DOL or not? And the key factors pointing to a potential DOL here is the length of the ambulance journey, the degree of monitoring and supervision, and the guidance itself accepts that it might provoke discussion amongst practitioners. And that's what this really is there to do, is to guide and provoke discussion and provoke questions so that further advice can be sought or further information can be obtained before you can finalise a view on it. And then finally, Tricia lives at home with support. She has dementia. She scalds her leg and requires medical attention. She does get into the ambulance after a bit of persuasion by the ambulance crew. She becomes agitated during the journey, and the ambulance crew during the journey have to restrain her briefly. Unlikely to be a DOL because of the short length of the journey and the short duration of the restraint. There are provisions within the Mental Capacity Act to deploy transient restraint if it's necessary and proportionate. So that's a hospital conveyance type setting, and as I say, it's an example of that case scenario approach that the guidance takes. So moving on to psychiatric settings, so the guidance explores different types of psychiatric settings, such as acute wards, so people can be detained under the Mental Health Act in acute wards, or they may be there as an informal patient, rehabilitation step-down wards, CAMS wards. It also reminds practitioners of the statutory guidance in relation to the use of force as per the Mental Health Unit's Use of Force Act. And it describes those liberty restriction measures to be aware of that might tip that balance into being a DOL. So, for example, blanket ward restrictions, locked doors, observation, monitoring. There are more. That's not an exhaustive list, but that's a few of them. A case scenario in a psychiatric setting, specifically a CAMS ward, is there on the slide. So Anna is 16 years old, suffers with severe anorexia. She's admitted to a CAMS ward run by an NHS Foundation Trust with a low BMI. Decision is made that she will require NG feeding or PEG feeding through her stomach wall, which is anticipated she is likely to resist. Physical or chemical sedation will therefore be required to minimise the risk of harm. And she will not be permitted to leave her hospital for a number of weeks during the refeeding process. So in this instance, the key factors pointing to there being a deprivation of Anna's liberty is the confinement condition is met. So the nursing care that Anna will be receiving while on the ward will mean that she is subject to constant supervision and control, and she's also going to be subject to physical chemical sedation. The lack of valid consent, Anna is unable to consent to her confinement, and no one with parental responsibility can do so. And the state responsibility condition is met. So Anna has been placed in a CAMS ward, which is managed and funded by the NHS, so that imputability to the state question is answered. It begs the question, well, what if Anna was 14 and if she lacked Gillett competence to decide on this? And it's suggested in the guidance that such arrangements would still amount to a deprivation of Anna's liberty, because the measures basically go beyond normal parental control for a non-disabled 14-year-old, and so she is confined. Whether Anna was deprived of her liberty would therefore depend on whether her parents could consent to the restrictions that are being placed on Anna, which in theory parents can do for under 16s. But given the invasiveness of this treatment, the significant restrictions placed on her, then in the guidance's view, and obviously I would agree, it would fall outside that scope of parental responsibility in that particular scenario. So moving on to care homes. Care home residents may be subject to one or more of a range of legal measures. So they may have a DOLS authorisation, there may be other legal measures at play. What the guidance does, again, is break it down into different care home settings. So for older adults, nursing homes, specialist mental health homes, or care homes for adults with learning disabilities. And it sets out potentially, again, those liberty restricting measures, keypad entry system, perimeter fence, assistive technology, escorted community access. So that checklist of factors, again, for care homes is there for practitioners to consider. There's another example here. I'm conscious of time, but you can, in your own time, if you like, look at these on the slides, because they will be circulated afterwards. But again, what this does is break down a case scenario where John, for example, likely to be deprived of his liberty. There's a plan in place there for, Jane. Sorry, I've lost my slide here. Just bear with me a second. John, yes. So subject to a full care order, has an LD and diagnosis of ADHD and presents with challenging behaviour. Restraint has been necessary relatively frequently. Contact is managed with his parents through once a week contact and communal lounge only. And if there's an incident, John is told to go to a quiet room and staff remain outside the door to check on him every 15 minutes. So again, the key factors there pointing to a DOL are the extent of the restriction on his movements, the use of restraint within the home, and the controls on his ability to leave the home temporarily or permanently. And then moving right down to someone like Rena, who is 35 and has a mild learning disability, and she's lived in a small group home since she was 15, but she can go about her day, relatively independent. She travels independently. She's been assessed as having capacity to make decisions about contact, and she manages that in the way that she decides to. So therefore unlikely to be a deprivation of liberty in those circumstances. Then it moves on to supported living. So a lot of people are living in supported living arrangements now. So it's only right that there is a separate chapter dedicated to that. And that's essentially the umbrella term for when a public body is arranging a package of care and accommodation in their own home of sorts. And it covers supported living, shared life schemes, and extra care housing. Now, as we know, this guidance is not about what you do if there is a DOL, but what it does specify that DOLS is not available for people in those environments, and an application to the Court of Protection for an order authorising the DOL would be required. And then again, it talks about the more common liberty restricting measures in this environment. So locked doors, CCTV, potentially restricted access to the property or parts of the property, use of chemical or physical restraint, the level of that background support that's sort of part of the core team as well is often an issue in supported living arrangements. And then again, there's a case scenario broken down, which you can have a look at in your own time. And then at home. So this means that a person at home can, of course, be deprived of their liberty if they satisfy the acid test. There's a little bit about private funders. So if someone is privately funding their care at home, is that said to be imputable to the state and therefore a DOL? And the court has sort of held generally that the state should know or ought to know that the circumstances of the care regime are such that they have sort of indirect responsibility to authorise the DOL. It does depend on the circumstances as to that level of state involvement, if you like. So it will depend on the circumstances, but the guidance does cover that. And again, when we're looking at the home environment, the guidance goes into that checklist of liberty restricting factors, and they apply in other settings as much as these ones as well. But that sort of physical or psychological support with aspects of daily living, that continuous supervision and monitoring, that's where you have to be careful to really consider whether there is a DOL present. And just touching on the case scenario here. So this is the at-home scenario. And you've got Veronica, who's 85 and is a widow living on her own. She has a history of mental illness and previous admissions under the Mental Health Act. She requires 24-hour care as a trial to see if she can still manage at home with that level of support. So she has a carer with her at all times. You know, pretty obvious that there is a DOL present there. And then through to someone like Susan, who is married to Jim, history of alcohol abuse on both sides, relationship can be volatile. She had a road traffic accident and now has an impaired cognitive abilities, but she has capacity on contact, but not residence and care. So Jim's going to be looking after her when she returns home. She's able to go out for short periods alone, but gets anxious and says she needs Jim to support her with that. Respite is arranged for Jim and the carers visit 2 hours a day, but she has no other care. So again, pointing away from a DOL there is that she's able to access the community on her own and so is not subject to continuous supervision and control. And her whereabouts in theory may not be known at all times. She wants the support from Jim to be able to go out and about. And then finally, the hospice palliative care setting, including at home, so there's specific guidance which explores palliative care in those environments. And in many cases, whether a person is deprived of their liberty will depend on the length of time they're going to be in there. So is it non-negligible or not? Are they free to leave or not? And have they given consent in advance? So some circumstances the guidance considers should be taken into account include whether the circumstances are no longer covered by consent, administration of sedatives or chemical restraint and restricting movements of the patient. So again, that's very much a case-by-case analysis that you have to take in those settings. There isn't a sort of blanket, if it's a hospice, there's no DOL. It really does depend on the individual circumstances. So some of the key takeaways then in my sort of review of this guidance is, yes, it's a lengthy document, but it is easy to navigate and it's very useful. It has a helpful settings-based approach and it explores example cases and scenarios for those settings to illustrate where there may or may not be a deprivation of liberty and just cause you to think twice and perhaps get advice if you need to. It does have a note of caution to it. So in some cases, the presence of one or two factors, these liberty restricting measures, may be enough to indicate there is a DOL, where in other cases, there may be many factors present, but they don't automatically amount to a DOL. So I think it's the nature, intensity and weight of those. But overall, it's a very useful document, as I say, and hopefully some of the breakdown of these scenarios on the slide will be useful. But of course, it's not a substitution for having the guidance to hand as well. And what I would say is, because it brings the case law up to date, the professionals don't have a statutory duty to have regard to it like a code of practice, but it would be worth using this to review and update your sort of MCA DOLS policies and internal training around DOLS as well. So that concludes the presentation session of the webinar today. Thank you all for joining.